events regarding COVID-19 and how judicial proceedings have been affected throughout the last year and a half. I feel like this picture does a pretty good job at demonstrating how the states have handled this situation, or at least tried to handle it in some sort of way. Yeah, you can't just blow this thing off. Basically, I want to kind of ask the question, how has the pandemic affected the rights of the accused, specifically, since that's the topic of our group? And the Supreme Court has left it up to the states to decide on how to handle court cases and trials. And I'm going to answer that question with how the pandemic has altered the judicial proceedings, with whether or not it's basically infringing on some of our rights, rights of the accused especially. And I'm going to say yes, I feel like it does to an extent. It basically nulls the speedy trial. You don't have a face-to-face option, essentially. And there's this really good article by Michael Fente written regarding this exact thing, actually. And on page 37, basically he says that, right? Like, because there is no face-to-face, it's different. It's handled differently, and it's not fair. So basically, what I've written in my the Sixth Amendment, I've kind of bolded, sections that I think that things have been overlooked, or not overlooked, but they definitely have been, with the virtual cases, I don't think that that's necessarily holding up to the Sixth Amendment, is what I'm trying to say. The accused shall enjoy the right to a speedy and public trial. And then to be confronted with witnesses, I mean, I take that as a face-to-face or in person, a physically present witness. So I feel like a lot of the states have gone to virtual for civil cases, but the article that I mentioned by Michael Fente actually covers a lot of that. And I don't want to just like put that off on him, but a lot of the states have enacted legislation specifically to address and mitigate disasters effects on the ability to file documents and proceed with their cases despite an inaccessible courtroom. So there are things already in legislation in a few states that navigate this murky water kind of thing. And another thing that he brought it to my attention was the fact that ordering the postponements outweighs the best interests of public and any defendant's right to a speedy trial. So I guess it kind of just is a balancing game of what's worth going to trial for and jeopardizing your health and everybody else's health. Because there was a court case in New York where the judge, like right then and there, said, we are going to postpone this because you have symptoms of COVID. And it kind of shut that case down for that time being. But it's a pretty complex ordeal we're in here. And so this is one of the ways that courtrooms are handling things now: in person, separated 6 feet, wearing masks. I find that that's pretty crazy.
Hi, my name is Eris, and for our Civil Liberties Group project, we were focusing on the rights of the accused, search and seizure. So the rights of the accused are the right to a fair trial, due process, seek legal remedy, and the right to participate in civil society. For our first one, since I was focusing on relevant Supreme Court decisions, I chose Miranda versus Arizona of 1966. This certain case was about a man named Ernesto Miranda, who was arrested by police and then gave his confession under his interrogation. Miranda's conviction was overturned by the Supreme Court because the police had not informed him of his rights. So Ernesto Miranda was not informed that anything he said was going to be used against him. This case led to the requirement that police must read suspects their Miranda rights. The Miranda rights are: you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to talk to a lawyer and have him present with you while you are being questioned, and so on. The second one we chose was Mapp versus Ohio. Police entered Dolly Mapp's home without a search warrant. They were tipped off that she had been hiding a fugitive. And although they did not find what they were looking for, they still handcuffed her and searched and went through her personal things. Police did find material that was illegal, but the Supreme Court sided with Mapp, saying that the police search was unconstitutional and cited the Fourth Amendment, which protects against unreasonable searches and seizures. And the court decided that this applied to the states, and unconstitutionally obtained evidence would be excluded from criminal prosecutions. This is a picture of her. And then a quote from the book says that the court held that evidence acquired through an unconstitutional search cannot be used to obtain a conviction in state courts. That's from Thomas Patterson. And then the last one we chose was Brady versus Maryland of 1963. This case was about John Brady and Charles Boblet, who John Brady was charged guilty of first-degree murder. However, Brady confessed to only robbery that happened before the murder, but not the murder. Brady and his partner were both given the death penalty. Brady found out later after his trial that Boblet, his partner, had confessed to the murder. The state of Maryland held that not letting Brady know about the confession denied Brady of his due process. This case made it so that the defense may examine evidence that is favorable to the defendant. And that's all.
Here are the Miranda rights. Hello, this is my group project, The Rights of the Accused. We're doing it under the rights of the accused, which is a search and seizure, self-incrimination, and the right to an attorney. Relevant constitutional provisions. This is case 1, Gideon and Rainwhite in 1963. Gideon was charged with breaking and entering with the intent to commit a misdemeanor, which is a felony under Florida law. At trial, Gideon appeared in court without an attorney. In open court, he asked the judge to appoint counsel for him because he could not afford an attorney. Despite his efforts, the jury found Gideon guilty. He was sentenced to 5 years imprisonment. Gideon kept going with the court claims and fought until there was a change. He filed his own handwritten petitions with the United States Supreme Court while in prison. Part 2. After the many attempts of trying to justify his case, the courts listened. They then announced that the right to an attorney is a constitutional guarantee to Gideon and anyone else the right to counsel in similar criminal cases. Back in Tallahassee, the Florida Supreme Court quickly announced that it was offering a new trial for Gideon. Gideon was then found not guilty with the help of local lawyer W. Fred Turner in Panama City. Another case similar to Gideon is Escobedo versus State of Illinois. A 22-year-old was arrested with his sister and taken into police headquarters for interrogation in connection with the fatal shooting about 11 days before of his brother-in-law. petitioner made several requests to see his lawyer but was refused access to his client. Then the petitioner was not advised by the police of his right to remain silent, and after persistent questioning by the police, so he was not read his Miranda rights, and then he was later interrogated by police. Which brings up the next case is Miranda versus Arizona, 1966. Ernesto Miranda was arrested by police and gave his confession under interrogation. Miranda's conviction was overturned by the Supreme Court because the police did not read his rights before interrogation. Miranda was not informed that anything he said would be used against him in the court of law. The case led to the requirement that police must read suspects' Miranda rights upon arrestment. Here are the Miranda rights before that are said to any suspects when being arrested. 1, you have the right to remain silent. 2, anything you say can be used against you in the court of law. You have the right to talk to a lawyer before advice, before we ask you any questions if there's so. And there are the rest. So the Miranda rights really made a change for everyone.
So now I'm going to be talking about legislation and executive orders that have to do with the rights of the accused. So the Fifth Amendment is something that's very important. It protects accused people against any abuse done by the government during legal procedure. It affects them from self-incrimination. And what that basically does is it protects the people from succumbing to pressure that the officers might apply. They can choose to plead the Fifth, as you've probably heard before in TV shows or in like legal proceedings. It also protects them against double jeopardy, which means that the government isn't allowed to appeal or try again after a verdict or decision was reached. So it encompasses 4 different prohibitions. It prohibits subsequent prosecution after acquittal, prosecution after conviction, prosecution after some mistrials, and multiple punishments in the same indictment. Something else that is part of the Fifth Amendment as well is due process. Now, due process is really important. There's 2 types of due processes. One of them is procedural due process, which is basically just procedures that authorities have to follow before officially punishing someone for an offense. And there's also substantive due process, which requires the law to be fair, just, and reasonable throughout the legal proceedings. So they basically have to, due process is basically all of the processes before the government decides to take away a person's life, liberty, and property. And I have another Supreme Court case here. And this is Katz versus United States, 1967. It was when a man by the last name of Katz was suspected of transmitting gambling information over a public payphone. And the FBI decided to tap the payphone to catch him, but he argued in court that the Fourth Amendment protected him because the Fourth Amendment, as you know, protects any people from unlawful investigations into their property. And because of that, he didn't know that they were looking for him or searching for him. He said that the Fourth Amendment protected him from that. But in reality, the court ruled that he couldn't plead the Fourth because the payphone wasn't his directly. It was just a public payphone, and that the Fourth Amendment protects people, not objects. And since it was a public payphone, it wasn't exactly his either, so that didn't really help. And then at the bottom here, I have the different decisions that the judges went for. And then here are my sources. Thank you.